Like if a friend, and I use that term loosely, because if it was a friend, they would never have said, hey, let's go to a bar to begin with. But let's say you go to a bar. A friend should not be buying you drinks. And if they are your friend, Portales and probation, this is an application. And counsel, you're on this side.
Thanks, Judge.
You're welcome. Court is calling 2024 CR 0125506, State of Texas versus Vanessa Portales. Can I have parties announced?
Megan Galloway for the state.
Ted Wood representing Ms. Portales.
And are you Ms. Portales?
Yes, ma'am.
Thank you for dressing appropriately for court. Counsel, have you received all discovery?
I have, Judge.
Did you review it with your client?
I have, Judge.
Court will find that the state is in compliance with discovery. Ms. Portales, did you review the application for community supervision with your attorney? Did you understand it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Judge.
State, are you proceeding on the indictment as presented? Any objection?
None, Judge.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with harassment of a public servant. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. If you have a plea bargaining agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
I didn't understand.
The rights that I've explained to you, do you understand them?
Yes, ma'am.
Are you intending to give up those rights and enter into a plea bargain agreement? All right, are you sure? She's sure she wants to enter into this plea bargain agreement, counsel?
Judge, I think she may be concerned about the waiver of the constitutional rights that you articulated, but I explained to her that those rights are waived for this proceeding and this proceeding only.
Huh.
So she's not giving up her rights for the rest of her life or forever and ever. It's for this proceeding and this proceeding only.
Do you understand?
Yes, ma'am.
All right, counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes,
Do you believe she's currently competent and was legally sane at the time of the offense?
yes,
Ms. Portales, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
you
I'm
have to
sorry.
say yes.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes,
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
yes, ma'am.
According to the plea bargain agreement, punishment is to be assessed at 6 years in the prison. There's a $2,000 fine. There's no application for deferred adjudication, and the state recommends community supervision. Did you understand that to be the plea?
Yes,
Defense, is that the plea?
Yes, Judge, probation was recommended, I believe, or community supervision for 3 years.
Well, that's a recommendation, but we're just going over what the plea bargain agreement is, which
Very
you all have agreed to.
Very
You
well.
understand that?
yes, ma'am.
All right, in defense, was that the plea?
Yes, Judge.
State,
I did, Your Honor.
did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, there been any such motions?
No, Judge.
Outside the agreement, the state is requesting that your community supervision be for a term of 3 years. There be a TAP evaluation, community service hours, and also no contact with a resident on Nogalitos Street, San Antonio, Texas, 78225. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
No objections, Judge.
And state, have you spoken with the complainant?
No, Judge.
Okay, all right, thank you. You may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand that you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same, and the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
I don't think there was a PSI requested, Judge.
No. So do you wish to proceed?
Yes, Judge.
All right. Anything you wish to say on behalf of your client?
Judge, Ms. Portales and I reviewed the situation, and she believes that it's in her best interest, and I agree with her that jury trial is not in her best interest. And the judge, we're just asking that you go along with the 3-year recommendation and give her a chance to rebuild her life.
All right. What do you do for a living?
I'm a Valley Living. I do work for the community apartment complexes.
Okay. And I'm sorry, what do you do?
For Valley Living, I pick up like their trash and stuff and put it in the compactor.
Okay.
I work a part-time job due to that because I do my GED. Right now, I'm in GED classes.
Mhm.
I'm studying for a truck driver, so I do work my part-time because of that. Put in my hours of school to make time for that as well.
Okay. And do you have any children?
My children are 23 and over, so
Do you have grandchildren?
no, not yet.
And when you say not yet, is there one on the way?
My daughter mentioned she just lost her baby. So
Oh, I'm so sorry to hear that. All right. So now the big question, why are you spitting on someone? Nobody likes to be spit upon.
I know. To be honest with you, Your Honor, I don't know if I'm able to talk about this to you, but I'm going to tell you, I don't remember what happened to me that night. I do remember when I was sober, one of my old growing up friends that lived down my street, they asked me to take him to the bar. And me being nice, and I hadn't seen him for over 50
So
years.
did you,
I ended up taking them to the bar and dropping them off at the bar. And they're like, hey, you want to come in so you can.
and did
go
you
in
drink as
there.
well?
And I went in there because I love pool. I've always liked to play pool as a child.
Mhm.
So I went in there and one of the girls that I took that we grew up from our childhood, she offered me a drink from the bartender. But they're like, when I got that drink, I hesitated to get it. But the drink, I believe that it had something in it. After that,
No, here's the thing.
I don't remember.
The problem is that it appears to me that you have issues with your sobriety and you should not have been drinking at all anyway. Let me tell you something, what I know. What I know is that if you are being clean and sober, there may be certain places that you should not go. But if you decide to go, like if a friend, and I use that term loosely, because if it was a friend, they would never have said, hey, let's go to a bar to begin with. But let's say you go to a bar. A friend should not be buying you drinks. And if they are your friend, then they know what your issues are. They know if you're trying to maintain your sobriety, because then we end up here. You understand?
Yes, ma'am.
So that person should probably be removed from your friends list. And they always tell you, you need to change people, places, and things. So sometimes mainly it's the people. You understand?
And you know what, Judge, I was telling my lawyer that from my childhood, we grew up in the same neighborhood. So I ran into her, seeing her. And when she asked me for the ride, I did all that and I took them. I hadn't seen this person for over 15 years. Now
you
that
know
we're
what?
adults.
Sometimes people are best left in the past.
Word.
Because when you break up with somebody, there's a reason you broke up with them. When you haven't seen a friend in a while, there's a reason why you haven't seen them in a while. So this is what the court is going to do. The court is finding you guilty. The court is going to sentence you to 6 years in the prison, suspended and probated for 4 years. There's regular reporting by Zoom or in person. There's to be regular random UAs, proof of employment within 30 days, no employment as a home health care provider or with minors. I'm going to order 90 sober meetings in 90 days. TAP evaluation out of custody Follow TAP recommendations. If TAP recommends inpatient treatment, we'll start with intensive outpatient treatment. There's going to be field visits one time per month for 6 months. 200 hours of community service restitution. If you obtain your GED or trade school certification, the community services will be deemed satisfied. So it's up to you whether or not you want to end up picking up trash in the heat of the summer in San Antonio. Probably going to be about 100 and something.
Warmish.
Yeah. So that's up to you.
Thank you, Judge.
There is to be no contact with 2432 Nogalitos, and that's 78225. Probation, is there anything else? All right, I'm not going to order the fine.
Thank you, Judge. Appreciate that.
Is there anything else you need from the court to be successful?
Thank you.
All right.
Thank you, ma'am.
And do you need anything else from the court?
May I have a work note,
What, for being here today? What do you mean a work note?
like just so I can have for my records?
I don't understand what you mean by work note.
Like, I just wanted to ask if I can have a letter for when I go back to work that they know that I came here.
Oh, no, I don't do that. That's something you have to get from your attorney.
Okay.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
All right, make sure you stay in contact with your probation officer, because in this court, to be successful, communication is key. If there's an issue, let your probation officer know about it. If you feel they're not addressing it, you can always come back to court. All right, thank you.
Thank you, Judge. May I be excused?
Yes, thank you. Deputy Laura, do you see Romero on the docket? The page he's on? It's Jose Romero, page 3. All right, thank you. Daniel Montoya. All right, first things first, defense, do you know when his competency evaluation is scheduled?
No, I do not. I didn't check with Judge Rodriguez's court this morning.
All right, Ms. Ferguson, can you look on Daniel Montoya and see when his competency is scheduled? And then you're asking for his bond to be reinstated?
Yes, Your Honor. And we're not objecting to the same conditions of leg monitor. For him he was actually at the Haven for Hope, and I was able to talk to him. And on the 20th, to let him know about the warrant.
Just 1 second, I'm sorry. Could someone pull the violation report on Daniel Montoya for me, please? Thank you. Let me just have them pull the
Okay.
report. Unless you have a copy of it.
Well, mine has writing on it.
Okay.
But may I just add this part, and I'm not going to talk about the violation report. What I'm going to talk about is that once I was able to get a hold of him, he does not have a cell phone. He was at the Haven for Hope, and I told him about the warrant, and he went and turned himself in on the 20th. With his leg monitor on. So just so the court will know that. And that's the relief we're going to be seeking, is that he had another address that Lifetime set up for him, but it was not workable. So he wants to go back to the Haven for Hope with the leg monitor.
That's the over the competency was sent over last week.
All right, thank you. All right, so I am not the one who signed the bond forfeiture. At least I don't think I am, because it doesn't show.
It was an after hours, Your Honor.
All right, so does anyone want to see the violation report?
State does have a copy, Your Honor.
And I have a copy.
So I understand that you're saying he was at the Haven for Hope, but my concern is the charge he has, and it says that he was at Gloria's Hideout, which is a bar, from 7:41 PM to 8:14 PM. And then he was at another bar, the Sunset Bar, from 8:35 PM to 9:42 PM. And then he went back to Gloria's Hideout from 9:44 PM to 11:35 PM. And he never returned.
Yeah, Your Honor, and if I misled you in any way,
Oh,
he
no.
went to the Haven for Hope after, right, on the
After the
20th.
bar runs?
Well, he never went in any bars. He doesn't have any money.
No, I
And-
mean, it says here that that's where he was.
No, there's a difference between being in a parking lot and being in a bar.
I'm just saying what this says. So he was there
So
and he wasn't supposed to be there.
he broke curfew. And that his curfew was 10 PM. Okay. So we're just seeking for him to, after he left there, he went to the Haven for Hope. And that's where he, on the 20th, and that's where he remained. They processed him in, even though he had a leg monitor, even with his charge, that he could stay there. And that's where he would like to go back.
All right, so to the clerk, could you pull for me the conditions of his bond? Just whoever put the conditions in. All right, so he was on partial GPS for employment and or school approved upon verification. So it wasn't a curfew. He was only allowed to be out and about if it was for employment. So,
And he was out and about because he did not like where Lifetime arranged for, like, in some, like home or a place where other people live. He didn't do well there. So, he was just roaming around, and then he decided to go to the Haven for Hope. That was his thing. Judge, he needs, that's one of the beauties of a Haven for Hope, is they'll have access to a telephone for people there to assist him, not only with his medication.
no, but we're still not addressing the issues that one, he's on GPS. It's not a GPS curfew. It's for employment or school only. And that's with approval. So he wasn't working and he was at, whether he went into the bar or not. Did you go into the bar? All right, so he's in a parking lot at two different bars.
And just for the state's record, there's no parking lots. These are on the side of the street. And I have those images pulled up.
So those are my issues.
Are you saying that this building has no parking, which would, they don't allow people to put businesses up without at least a few parking spaces? So I'm not sure about that. But, Your Honor, I think the issue here for him is where can he continue getting his mental health and be in a more secure place than Haven for Hope, where he can have his mental exam, he can come to court, he can do all of those things. Locking him up doesn't serve a purpose, just he's now going backwards. Because at Lifetime, he was put on medication, he was getting counseling, and
he
now
left Lifetime.
everything is, a Lifetime is great. Now everything is going to be undone. Keeping him in jail doesn't help him, because we know that there's not a psychiatrist that's going to come by today when he gets back and say, hey, how are you doing? You know, how are your medications going? You know, he can't take anything unless a
Well,
psychiatrist
the
sees
problem
him.
is he's on GPS. I don't take the offense as true or not, but I do have to go by the fact that it's an aggravated assault with a deadly weapon. And,
This is his first violation, Your Honor.
and he's on curfew. I mean, not on curfew. He's on partial for employment or school only. And we got the tattoo things that are going on here. Yeah. State, are you in agreement with reinstating?
We are not, Your Honor. The state will remind the court that we were here last time on the 17th, which was the day before this for a sentencing hearing, where the defendant was supposed to be sentenced. There was an issue of competency, so he was released, or not released, I'm sorry, I guess, walked out with the GPS monitor, and the next day he goes to two different bars. The state's concerned that he's violating his pretrial conditions. He's not taking the orders of the court seriously. He is going to bars whether he went in or not. I don't have any proof otherwise, but if he's just standing in parking lots of bars, that's also concerning. Additionally, he is a repeat offender and on for a violent offense, which has 2 counts with 2 different victims.
All right.
And so at this time, the state's just.
All right, and also with regards to reinstating the bond, it will be up to the bondsman, number one, whether or not they want the bond reinstated, because I cannot reinstate a bond when there is a commercial bond unless the bondsman has no objection to that. So honestly, I'm not inclined to reinstate his bond either way.
Well, Your Honor, the reason to put him on leg monitor is keeping away from the target, from the individuals that alleged to have been a victim of alleged crime, Your Honor. And that didn't happen. So we're not, the purpose of the leg monitors to keep him away from them. And that he was successful in doing, Your Honor. All throughout when he got out on bond and since he's been on leg monitor.
All right. So
So we're asking for a second chance, Your Honor, because the purpose of the leg monitor, the spirit of the leg monitor was obeyed.
all right, the motion is denied. I will not reinstate the bond. And we can go on the record. Court is calling 2024 CR 011984, State versus Daniel Montoya. Can I have parties announced for the record for the state defense?
Arlene Gay,
And are you Mr. Montoya? I'm sorry, Daniel Montoya. Thank you. All right, Mr. Montoya, your attorney filed this motion to reinstate bond. As I've stated off the record, the court cannot reinstate bonds for a bondsman unless that bondsman informs the court that they want the bond to be reinstated. So the reinstatement of the bond is going to be denied.
if the bonding company comes to you, Your Honor, and they haven't filed an affidavit to surrender surety.
Mhm.
So it was an order from another judge that issued an arrest warrant. So if the bonding company lets the court know, we want to still be on this bond, does that mean the court is saying that you will allow him to continue outside in the free world on bond?
Now, what I'm saying is the first hurdle that the defense has in reinstating a bond is whether or not the bondsman wants the bond reinstated. The court has nothing before it suggesting that the bondsman wants the bond to be restated. So before we even get to the state's argument about why it should not be reinstated, the first hurdle is the bondsman. And the court has no information before it that the bondsman wants to continue to be on your bond. So reinstatement is denied.
Okay, Your Honor.
And if
Can we-
you,
I'm sorry, Your Honor.
no, if you speak to the bondsman and you all want to reapproach after you've spoken to the bondsman, you're an officer of the court, I'll accept whatever you state the bondsman has said. Then we can come back and then we'll go to the next steps.
Okay, great. Thank you, Your Honor.
You're welcome. You're welcome. Brian Pena. Good morning. Any traveling for you?
Thursday,
Where are you headed?
Mexico City.
All right. I always love your ties.
Thank you.
All right. On this case, so today is your plea deadline date, is that correct?
That's correct.
So Mr. Pena, are you requesting a jury trial? You need to speak up.
Yes, ma'am.
All right. How long do y'all expect this trial to last?
I was gonna say more four, just because of the amount of witnesses,
All right.
and we would be going to, if anything, jury for punishment. So
All right. Ms. Ferguson, I need a jury trial date, 3 days, not including jury selection for this case, please. It's criminal trial division. All right, July 8th. Is everyone agreeable to July 8th?
So just to understand how that works, we picked July 8th.
Yes.
Okay, then yes, that would work.
Yes, Judge.
Okay.
Yes.
All right. What will happen is you'll be brought back July 8th for jury trial. You'll be brought over dressed in whatever attire you have at the jail, whatever civilian clothing you have. If you wish to be attired in something different, you'll have to sign a clothing exchange. And
got it.
counsel, if there's an issue with the clothing exchange, just let the court know and we'll see if we can expedite that.
I got it, Cyrus. I'll take care of it.
All right, thank you. And before you all leave, if the court can get an acknowledgement of discovery.
Yes, Judge.
All right, thank you.
Thank you.
Oh, I'm sorry, sir, your plea deadline date has expired. The court will not accept any plea bargain agreements in this case without good cause. Otherwise, you have to plead open to the court. Do you understand? All right, thank you.
Thank you, Judge.
Good morning. How's it going?
It's going.
Where is the pen?
Judge.
I don't know
I
yet.
think I was coming to see you today. I usually try to pin one on if I know.
All right, so we are here on a motion to revoke. Are both parties prepared to proceed?
Oh, I'm sorry. It's right here. It's under my sister.
All right, the court is going to call 2024 CR 1983, State versus Ashley Yvonne Draper Ward. Could I have parties announce?
Andrew Harris, Salem for the state.
Melissa Christian for the defendant.
All right, and Norma, could you hand me a file stamp for a motion to revoke? And are you Ashley Yvonne Draper Ward? You're gonna need to speak up.
Yes, Your Honor.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Ashley Yvonne Draper Ward who was placed on deferred adjudication in 2024 CR 1983 for the offense of attempting to take a weapon from an officer on June 27, 2024 for a term of 4 years? Is that you?
Yes, Your Honor.
All right, state.
On or about the 23rd day of December 2024 in Bear County, Texas, the defendant Ashley Yvonne Draper Ward committed the offense of tampering with electronic monitor violation.
How do you plead to that? True or not true?
True.
State waives the remaining violation allegations.
Any objection?
No, Judge.
All right, did you understand by pleading true to violation condition number 1, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, Your Honor.
Court will find violation of condition number 1 true. Is there a proposed agreement?
There is not, Judge.
State, what are you requesting?
Adjudicate guilt, assess punishment at 2 years of confinement in the state jail facility.
All right, and defense, what are you requesting?
Judge, she has 415 days credit. So we are asking the court to give her credit for time served.
All right. So you want to raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Ashley Yvonne Draper Ward.
All right, what have you done while you've been on probation? Well, let me do this. Did you complete parenting classes?
I did several of them.
But did you complete it?
No, ma'am.
Why not? Deputy
I
Laura,
left the program
excuse me, you're not dressed appropriately for court. Yes.
because I left the program, ma'am.
All right, why did you leave the program?
I acted on impulse.
All right, that doesn't explain why you left the program. What was the impulse you were acting on?
Just overwhelmed. There was a lot going on up there and I just got fearful when I left.
All right, did you complete anger management?
Yes, Your Honor.
All right. And with regards to the referral for Center for Healthcare Services, had you been in contact with them?
Yes, Your Honor.
And were you employed?
Yes, Your Honor.
Doing what?
Worked at Little Caesars and then I was a home health care provider.
Oh, see, I don't even know why that's being allowed because I don't allow people to be home healthcare providers. And I specifically said no employment as a home healthcare provider. You're overwhelmed by life and yet you're somebody's home healthcare provider. But I don't allow people who have felony cases to be home healthcare providers.
Yes, Your
So
Honor.
that's number 1. Probation, what are you recommending?
Judge probation's recommendation is to amend for safety followed by aftercare.
All right. You have a choice. You can go to safety or I can revoke you. And if I revoke you, I'm sentencing you to the 2 years. Either way, time is going to pass in your life. It can either pass with you in safety and you're going to get extended on this probation, by the way. If you go to safety, I'm going to extend you for a year. So if you want to just do your time, you can do your time. You can go to the state jail facility. I'm going to sentence you to 2 years, or I will send you to safety.
You'll get credit. The judge will give you credit for time served. State jail does their own calculations.
All right, this is what the court is going to do. The court is going to find you guilty. The court is going to sentence you to 2 years in the state jail facility, give you credit for any time served. There's a $500 fine, time and money for run concurrent. And I'll recommend the therapeutic community. All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
You have a limited right to appeal, and that right to appeal is that it relates to the allegations in the motion, not the fact that you are in deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you will need to speak to an attorney. So you're going to be sentenced to the 2 years in the state jail facility. You are entitled to whatever time that you've previously served. And I'm going to recommend the therapeutic community. The therapeutic community is to help you hopefully get your life in order so the criminal system will not see you again. Do you understand?
Yes, Your Honor.
All right, good luck to you.
Thank you, Judge. May I be
Thank you.
excused?
Yes, thank you. Court is calling 2024 CR 0111378 State versus Daniel Chapa the fourth. Could I have parties announced?
Megan Galloway from the state.
Brian Kimbrough from Mr. Chapa.
And are you Mr. Chapa?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Probation, there are no applications. Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do.
State, are you proceeding on the indictment as presented? Any
No
objection?
objection.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with possession of a controlled substance penalty group 1, less than 1 gram. That is a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you were giving up those rights. Did you understand?
Ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Chapa, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
Oh, ma'am.
Anyone promised you anything other than the plea?
Oh, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain agreement page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishment is to be assessed at 9 months in the Bear County Jail under 1244. There's an $800 fine, and the state is taking in consideration 2024 CR 0111211. Did you understand that to be the plea?
Yes. Am I getting back time? Yes, ma'am. I understand.
Defense, is that the plea?
That is the point.
State, is that the plea? Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State, any evidence?
State of First State's one of the attachments.
No objection.
Did you review the waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? And state, you may be excused. Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront
Yes, ma'am.
any witnesses the state would call in the right to remain silent?
Ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, he's been in jail for, I believe, 129 days on this case. I spoke to his family. He does have a lot of family support. I'm asking the court to file a plea bargain.
All right, so you have a lot of family support?
Mhm.
Then why won't you do right?
That's what they get mad at me all the time.
No, I mean, I'm not mad at you. I'm just wondering why won't you do right? Here you are.
All short.
Here's the thing, you're falling short a lot. And let me just tell you something. You're worried about whether you're going to get credit for any time served. Legally, I have to give it to you. If I didn't have to give it to you legally, I probably wouldn't give it to you. And the fact that you are sitting out here tattooing weapons on your face and doing all this extra nonsense, which is nonsense. I don't know what your plans are. Who do you think wants to hire you or would hire you with a weapon tattooed on your face?
It's hard for me to get a job. I regret.
Yeah, it's hard for you to get a job, and yet you continue doing foolishness. You started with the neck tattoo, and I always tell people, here's the thing. I don't have any problem with anybody having a tattoo. Go forth, be you. But if you're trying to get employment, maybe you should consider not having tattoos that come above the clavicle.
You're
You
right.
understand?
You're honestly right.
All right, the court is finding you guilty. The court will sentence you to 9 months in the Bear County Jail under 1244. There's an $800 fine. I'm not running time and money concurrently. Take in consideration 2024 CR 011211. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. Do you love anybody more than you love yourself?
I do.
And who is that?
Family.
All right, so here's the thing. You're using drugs. There are plenty of places in Bear County that will give you help with your drug addictions. Don't make it hard on your family by either spending the rest of your life in somebody's prison or somebody's jail, or because you've overdosed or you've gotten a bad batch of drugs and there's somebody that needs to be identified. You know who they call in to identify the body? Family members. Don't put that on your family. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
Thank you.
You're welcome. I mean, it happens. People always think it can't happen to them.
Me and Mr. Guerrero are okay. I think this is verification, a date for us. That he still wants to use the water, and we do. Scott Sullivan for Mr. Guerrero, Your Honor.
All right, hello.
Good afternoon.
Good afternoon. Let me see. All right, so on this case, where are we on discovery matters?
If I could briefly,
Yes.
quickly, and I spent a lot of time with him last week and this weekend.
Mhm.
And do you still want me to be your lawyer, sir?
Yes, sir.
You're comfortable with that?
Yes, sir.
And Judge, I thought that was one of the base reasons. And we've got most of the discovery, I think. And I think I need to check with them on a few other matters.
Okay.
Likewise, I need to talk with somebody, with an attorney who's on the panel, but also was up in Denver, Colorado as a previous, he used to work arsonist. And he might be my expert. I'll talk to him about that and approach the court in the days to come about that. Whenever the court wants us, set us for trial, we can go, but like a little, maybe a month or so for me to get it. I don't know. I don't want to tell the court how to run its talking, but it would be helpful if we could get that. Oh, and last thing, we do have a motion for PR bond for him. If the court could set that maybe later this week, I'll
Yes.
have some witnesses here.
All right. All right, Ms. Ferguson. Are we able to call back this week or next week for a hearing on a request for PR bond?
Yeah,
All right. So that's the earliest we can do it, okay?
31st is fine. I'll be here.
I'll set, so March 31st will be for your motion for a PR bond. And then the next thing is I need a plea deadline date of 30 days, please. All right, so April 24th will be your plea deadline date. On that date, you need to let the court know whether or not you've reached an agreement with the state. If you have not, your next court date will be your jury trial date. Do you understand?
And I wanted to make sure I had the dates right, the 31st for the motion.
Yes,
And then what was the other one, Your Honor? I apologize.
plea deadline.
Plea deadline.
Yes.
And thank you, Your Honor.
All right, thank you.
Now be excused.
Yes. All right, is this a plea?
Yes, it is, Your Honor.
Court is calling 2024 CR 0083005 State versus Cavanta Tyrone Thomas. Could I have parties announced?
Megan Galloway.
Anthony Miller for Mr. Thomas.
And are you Mr. Thomas?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, I have.
Court will find that the state is in compliance with discovery. Mr. Thomas, did you review the application for deferred adjudication with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, we do, Your Honor.
State, are you proceeding on the indictment as presented?
No objection.
All right, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with aggravated assault with a deadly weapon? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication? If for any reason if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. Did you understand?
Yes, ma'am.
By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into this plea?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe he is.
Mr. Thomas, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Off the record for a moment. Cindy, you need a cough drop?
Yeah, yes.
Okay. Do you need any water?
Yeah, I've got a drink.
Okay. Just let me know when you're ready.
Okay.
All right. Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on count 2. Punishment is to be assessed at a cap of 4 years in the prison. There's a $2,000 fine. The state is silent on your application. This will run concurrent with 2024 CC 740267. The state is taking in consideration 2025 CC 002368. Did you understand that to be the plea?
Yes, ma'am.
Defense?
That is correct, Your Honor.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am, I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to count 2, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
We've had an opportunity to review, Your Honor. We have no objection.
All right, and state, have you spoken with the complainant?
Yes, Judge.
All right, thank you. Did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am, I did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments and review the same.
Yes, ma'am.
All right, after reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
We're willing to do that, Your Honor.
All right, anything you wish to say on behalf of your client?
Yes, Your Honor. At this particular time, Mr. Thomas has fully acknowledged that he handled the situation improperly. He did not intend to harm anyone or cause any type of conflict, Judge. He was under the impression that this individual had taken items from him and were tracking him on his
Well,
phone.
according to the stipulated evidence, he was correct in his assumption. So here's the thing. At the end of the day, I understand that people get frustrated when people steal things from them because people have worked hard for what they have. Why somebody needs some Louis Vuitton earbuds, that's what people can spend their money on whatever they want to spend their money on. But this is definitely not the right way to handle things, because when you do that, so many things could have gone wrong. You understand?
Yes, ma'am.
All you had to do was call the police and said, these are where the earbuds are. I'm tracking them. That's it.
Yes, ma'am.
Now, guess what's going to end up happening? Now you're going to be on deferred adjudication for a felony when all you had to do was pick up the phone. And then I will tell you this, if things would have went truly sideways and you would have ended up perhaps killing somebody, or you perhaps being killed, then we'd be in a whole different situation because you'd be charged with murder. You understand?
Yes, ma'am.
So the fact that, there's a theft, that is no excuse. Okay?
Yes, ma'am.
All right. Are you employed?
Yes, ma'am, I am.
What do you do?
I drive 18-1,
Okay.
a third-party contract for the military.
All right. And do you go out of state?
No, ma'am.
Okay. So do you just drive throughout Texas?
Yes, ma'am, correct.
Do you have any children?
I have one,
Age?
3.
All right. And see, they were asking for forced silent. You could have been away from your child for 4 years if I would not have granted your application. You understand?
Yes, ma'am.
So you got to start making better decisions.
Yes, ma'am.
All right, this is what the court is going to do. The court is going to sentence you to 3 years deferred adjudication. There's to be regular reporting by Zoom or in person. There's to be regular random UAs, or there can be the patch. The patch costs more, but since you're a truck driver, that may help you as far as taking UAs.
Yes,
The
ma'am.
patch is a device that they put on you. You're not allowed to remove it. They put it on, and then you come back when it's time for it to be removed, and then they'll see if there are any positives. You understand?
Yes, ma'am.
There is to be proof of employment within 30 days, no employment as a home health care provider or with minors. He's allowed to travel. State, any objections to allow him to travel throughout the state of Texas for his employment? He's a truck driver. All right, he's allowed to travel throughout Texas for employment. Just make sure you let probation know. You understand?
Yes, ma'am.
There's going to be 100 hours of community service restitution. I'm going to order parenting classes. Once that's completed, the court will deem 50 hours satisfied. I'm going to order anger management. And once that's completed, the remaining 50 hours will be deemed satisfied. There's to be field visits 1 time per month for 3 months. Probation. Is there anything else? Is there anything else you need from the court in order to be successful?
No, ma'am.
Judge, the only thing we bring to the court's attention is Mr. Thomas is currently on GPS full house arrest. So we would like, of course, to have that removed.
All right, and I'm sorry, just 1 second. Take in consideration 2025 CC 002-368. And this is the run concurrent with 2024 CC 740267. State, with regards to the GPS, any objection to the removal? All right. And the court will order GPS removal. And there is an affirmative finding of deadly weapon. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. Is there anything else that you need to be successful on this probation?
Just you give me another opportunity to get my life back straight.
She has.
And
All right, so here's the thing. When you're on probation out of this court, on probation anywhere, you're not allowed to drink alcohol. You understand?
yes, ma'am.
In this court, to be successful on probation, communication is key. If there's an issue, let your probation officer know about it. If you feel they're not following the court's instruction that allows you to travel throughout Texas for employment, tell probation. That's what the judge ordered. If there's still an issue, you can always come back to the court and address it. Do you understand?
Yes, ma'am.
All right, thank you for dressing appropriately for court, and just remain in the courtroom, and probation will go over conditions.
Yes, ma'am.
All right, good luck.
Thank you very much, Your Honor. May I
welcome.
be excused?
Yes.